SB 1433. Imagine this. Imagine you're suing the state because you believe a new law unfairly affects your family. You ask the court to see emails and records that show how and why that law was written. Before you can get those records, the Attorney General steps in and says, those conversations are protected, and the process pauses. What the bill says it does. SB 1433 says it protects legislative privilege in court. It allows the Texas Attorney General to formally claim that certain lawmaking communications are protected during lawsuits challenging state laws. What it actually does? This means the Attorney General can now assert legislative privilege early in a case while challengers wait for the office to prove it represents the right official. That gives the state more control over what information is shared in constitutional lawsuits, while plaintiffs lose access to some records that might explain why a law was created. Who benefits? The Texas Attorney General, state agencies and officials being sued, lawmakers whose internal discussions are shielded. Who pays the price? Texans bringing constitutional challenges, civil rights and voting rights plaintiffs, communities trying to prove discrimination or unfair treatment. Why it matters. When people challenge a law, the only way to prove unfair intent or unequal treatment is often through internal records. If access to those records becomes harder, it becomes harder to hold government accountable. That does not show up in your taxes, but it shows up in whether everyday Texans can fully question the laws that affect their schools, jobs, and rights. Bottom line, SB 1433 strengthens the state's shield in court, but it may narrow the public's path to accountability.